Hey everyone, my name is Cliff Kirsch, and I'd like to welcome you to the Eversheds Sutherland Webcast Advisors Act Regulatory Series third quarter update. I'm joined today by Eversheds Sutherland attorneys Michael Koffler, Brian Rubin, Issa Hanna, Ben Marzouk, Bria Adams, and Sue Lee. And this program is our latest webcast of a quarterly series of webcasts dedicated to issues impacting investment advisors. Just a couple of quick housekeeping items before we begin. If you would like to receive CLE credit for this webcast, please download the CLE sign-in sheets and evaluation form from your viewing console and follow the instructions for submission. And if you have any questions during the webcast, please submit them via the Ask a Question text box on your viewing console. Also, in terms of the slide deck, if you want to receive a copy of the slide deck, please contact any one of us, and we'd be happy to get you a copy of that. So we have a lot to cover today, and we're going to go right into it. We're going to begin our discussion talking about the Best Execution Risk Alert that was issued pretty recently, and then we're going to give an update on the trading away enforcement cases, an update on the SEC Standard of Conduct Rulemaking, testimonial and pay-to-play enforcement cases, an update on the SEC share class self-reporting initiative, and then mention a couple of other SEC recent enforcement cases. So a lot to cover. And with that, Bria, I'm going to hand it over to you, Bria Adams.
Thanks, Cliff. In July, the SEC issued a risk alert in which it identified compliance issues related to best execution. The SEC identified 8 common deficiency issues among its 1,500-plus advisor examinations. Once advisors have had an opportunity to reflect on the issues identified by the SEC, they should consider possibly amending their disclosures, revising compliance policies and procedures, changing practices, and assessing and strengthening systems. So the first topic that the SEC addressed in their alert was advisors not performing best execution reviews. The goal of best execution review should be to evaluate the performance of broker-dealers used to execute trades. The SEC found that SEC advisors were not completing reviews periodically. They weren't completing reviews systematically, meaning that they needed to see defined processes or methods for completing evaluation of broker-dealers, and they were not seeing that in their advisor examinations. The second topic that the SEC noticed a trend around was advisors not considering materially relevant factors during best execution reviews. Advisors should evaluate the full range and quality of services provided by broker-dealers, including commission rate and the value of research provided, but advisors should also think about the execution capability, financial responsibility, and responsiveness to advisors' needs. The SEC also emphasized the importance of involving key stakeholders in best execution reviews, for example, soliciting and reviewing input from traders and portfolio managers. The third area of trends that the SEC mentioned were advisors not seeking comparisons from other broker-dealers. So advisors need to seek comparisons from competing broker-dealers initially and or on an ongoing basis to assess their chosen broker-dealer's execution performance. In addition, advisors must do more than just review a brief summary of the broker-dealer services. The SEC stated that advisors also must do more than just a cursory review of broker-dealer policies and practices when seeking comparisons from other broker-dealers. The next area that the SEC identified was that advisors were not fully disclosing best execution practices. The SEC staff observed advisors whose best execution practices didn't align with their disclosures in Part 2 of Form ADV. So advisors should make sure that they're fully disclosing their best execution practices. Also, if applicable, advisors must disclose that certain types of client accounts trade after other client accounts and the potential impact of this practice on execution prices. So the takeaway here is full disclosure, aligning your best execution disclosures with your best execution practices. And the next area that the SEC identified trends for deficiencies were regarding to soft dollar arrangements. Advisors must adequately disclose soft dollar arrangements under Item 12 in Part 2 of Form ADV. The SEC noted that advisors were not disclosing that certain clients may bear more of the cost of soft dollar arrangements than other clients. And as stated in the instructions for Part 2 of Form ADV, the SEC does require a more detailed disclosure of soft dollar arrangements when the products or services that the advisor receives from broker-dealers do not qualify for the Section 28E safe harbor. The next area that the SEC identified a trend of deficiencies in was that advisors were not properly administering mixed-use allocations. So advisors should make sure that they make a reasonable allocation of the cost of a mixed-use product or service according to its use, and that they are producing support for the rationale for mixed-use allocation. So documentation around those allocations is necessary, and the SEC is looking at that during their examinations. The next area that the SEC noticed trends around were inadequate policies and procedures relating to best execution. So advisors should have policies relating to best execution. They should have sufficient internal controls to monitor execution performance. And the advisor's policies must take into account the current business of the advisor, and also should be tailored to the advisor. And finally, the last area that the SEC noticed trends in were advisors not following best execution policies and procedures. So in addition to having those policies and procedures, advisors must also follow the policies and procedures. They must allocate soft dollar expenses in accordance with their policies, and they must follow internal policies regarding the ongoing monitoring of execution price, research, and responsiveness of broker-dealers.
And thanks, Bria. And you know, a lot in the risk alert is not new. It's statements that advisors have heard from commission staff in the course of examinations, at conferences, etc. There's an emphasis on process. Best execution has really always primarily been about disclosure and process. And a lot of the comments that Bria went over get into process in terms of the reviews, the quality of the reviews, the scope of the reviews, the documentation of the reviews, allocation of mixed-use products, use of soft dollars, factors that are taken into consideration in the analysis, the periodic evaluation that the staff expects advisors to engage in. So it's mostly process and disclosure, not a lot of second guessing, as long as you have good documentation on the process and the factors that are taken into consideration. So most of the things cited by the staff really were low-hanging fruit and should not present problems for advisors. But I'll just mention best execution is one of those perennial topics that always comes up. We seem to be in a heightened period of best execution review. You see that even in the share class initiative. You see that in the topic we're going to discuss shortly in terms of trading away in wrap context. So best execution is just we're on the periodic rise of best execution being an issue.
You know, and as Michael notes, a related development is the recent trading away in wrap fee program cases, and Issa Hanna is going to cover that.
Thanks, Cliff. And it's funny to mention, while Bria was discussing the Best X risk alert, a question just came in from somebody asking whether we have any thoughts on obligations of registered investment advisors who are sponsors of wrap programs to test Best X practice of hired investment managers. And actually, we do. We have a few slides here that we're going to go through to speak about specifically that topic, precisely that topic of Best X in wrap fee programs, specifically relating to trade away practices. If you guys might recall, there were a number of cases that the SEC has brought over the past couple of years, and really this goes back to 2014 when the SEC began a sweep with respect to this issue and included this issue in their 2014 exam priorities letter. Subsequently, the issue resurfaced in the 2017 and 2018 SEC exam priorities letter. So it shows that this is an issue of ongoing concern and kind of speaks to Michael's point earlier just now that best execution is really one of the hot topics and the issues of the day for the SEC when it comes to the regulation and enforcement of the investment advisory community. I mentioned earlier that this has kind of been an ongoing issue and that there have been a number of cases or a number of enforcement actions taken by the SEC. We've listed out the actions here. The four previous to the most recent were the Riverfront, Raymond James, Robert Baird, and Stifel Nicholas cases. We actually did discuss those cases in a prior webcast. If you're interested in that prior discussion, we discussed them in the April 2017 webcast that we did last year. But we thought we would revisit the issue because a significant new case recently came out just this past August against Lockwood Advisors, and the case offers some new lessons that I think will be important to consider for both advisors who sponsor RAP fee programs as well as advisors who recommend RAP fee programs and portfolio managers, specific portfolio managers to their clients. That's an important new development with respect to Lockwood. So before we get into the Lockwood case, I thought I would kind of level set here and provide just a basic run-through of what the typical scenario or the typical fact pattern was in a lot of these cases. Typically what you have going on is that you have investment advisory clients enrolling in RAP fee programs where the client's paying an all-in fee. The fee is supposed to include the cost of the advisory services, all of their trade execution costs, and theoretically they shouldn't be paying more for any other fees because that RAP fee is supposed to cover it all. But, in some situations, in some of these cases, you have portfolio managers who are hired to manage client money who choose to trade away from the broker-dealer who the sponsor designates as the executing broker-dealer in connection with the RAP program. And the portfolio manager might do that for any number of reasons. Maybe they believe that they can get best execution elsewhere, or they prefer to use a different broker-dealer. Whatever it is, they choose to trade away from the sponsor broker-dealer. And the result is that the client is charged a trade execution fee that's in addition to the RAP fee that they're already paying. And what the SEC has been mainly concerned about in this area, there have been a number of issues that they've pointed to. First, whether the clients are being overcharged for trades. Is it really fair to be charging them the RAP fee, which is supposed to include all of their trade execution costs, plus the additional trade away fees? They're also asking whether clients are really getting best execution. Is the trade away really worth it? They're also asking what's being disclosed to the clients. Are the clients aware of how much they're paying, how often their portfolio managers are trading away, et cetera? And finally, the SEC is asking whether the RAP fee that's being charged to the client, or the structure, that fee structure, is suitable and appropriate for the client considering the trade away fees. And also they're asking whether the portfolio managers themselves are suitable for the clients depending upon how much they're trading away. And all that goes back to the cost that they're incurring. So just a quick run through of the previous cases which we've discussed. If you're interested in a more fulsome discussion or review of these cases, I'd encourage you to take a look at our previous presentation from April of 2017. But in the Riverfront case, that was simply a case where you had an advisor, RAP fee program sponsor, whose trade away practices changed, but their disclosures didn't keep up with it. In the Raymond James and Robert Baird cases, those were really policies and procedures cases where the SEC found that both firms had insufficient policies and procedures. And then in the Stifel case, You also had a policies and procedures issue where, the policies and procedures were deemed insufficient by the SEC. But then you also had a suitability issue, which kind of foreshadowed the Lockwood case, where the SEC found that the firm's investment advisor representatives were not being provided with sufficient information about tradeaways to make an appropriate suitability determination as to whether a particular portfolio manager or the RAP fee program in general was appropriate for clients. So moving on to the Lockwood Advisors case in particular, the topic du jour. The Lockwood case really offers some significant new lessons for RAP fee program sponsors, and in a moment I'm also going to highlight some lessons that in particular anybody who's recommending a RAP fee program or recommending a specific portfolio manager can take away from this case as well. But with respect to program sponsors, one thing that you can take away from the case that I think is new and important is the SEC's focus on the importance of doing an initial diligence of a portfolio manager before you add them to the lineup of portfolio managers that are available in connection with a RAP fee program. That's a big distinction between this case and the prior cases that the SEC is really bringing up now for the first time, and the reason why the SEC keyed in on that issue was because of a gap that the SEC identified. The SEC basically said that Lockwood had policies and procedures to do ongoing diligence of trade-away practices of portfolio managers, but there could be a gap between when a portfolio manager was added to the platform and when they came up for review. So, and during this gap, you had the issue of third-party investment advisors, investment advisor representatives, who are recommending a particular portfolio manager or the RAP fee program in general, who just didn't have the information available to them in their possession to make a proper suitability determination. They didn't have information available to figure out whether a particular portfolio manager was engaging in too much trading away to make the portfolio manager unsuitable for the client. So that's a significant change. Another significant aspect of the Lockwood case is that they lay out in more granular detail in this case what types of data points a program sponsor should be collecting from portfolio managers as they evaluate whether the trading away practices of the portfolio manager are appropriate for the program, and also whether as part of their determination of whether the portfolio manager is meeting the overall best execution obligations. Finally, the last significant aspect of this case is that the SEC really focused on Lockwood's failure to provide third-party investment managers, investment advisor representatives, what have you, with the information that they were collecting about the portfolio managers and their trading away practices. That was a significant gap in their policies and procedures, according to the SEC, is that while they collected the information, they didn't turn around and provide it to the people who were actually recommending the portfolio managers and recommending the RAP fee program in general. So that was a gap that the SEC identified. Just a final thought here. The SEC is not trying to communicate here that trading away is per se impermissible. There are circumstances in which trading away is permissible, and the circumstances would be when it would be in the client's best interest and meet the overall best execution obligation to trade away. So just that final thought that the SEC is not trying to say here that it's flat out illegal to trade away. It's a matter of what's communicated to clients, what kind of diligence you do, and meeting your overall best execution and suitability obligations.
Great. Yeah. Thanks a lot. So we have a couple of things going on. We have the best execution risk alert that Bria mentioned. Then we had the trading away cases that Issa just summarized, the most recent Lockwood. And just to make note of a question that came in, and we'll get to it later, but a third aspect of this is best execution showing up as part of the share class initiative cases. And we'll get to the share class initiative later, but again, best execution sometimes shows up in the settlement, sometimes not. And again, just as a placeholder, we'll sort of get to that, the share class initiative later on. I think Michael was going to add a couple things on Best X.
Yeah, no, I think the Lockwood case is a really interesting case. Just to emphasize something that Issa just said at the end here, that trading away is not necessarily illegal, and actually had clients be examined, and one of the questions examined is, why did you not trade away? Damned if you do, damned if you don't. Of course, like everything with best execution, the answer is it depends. There are times, certain types of bonds, certain types of instruments that there are boutique broker-dealers out there that specialize in trading those particular types of instruments that have a lot of expertise on valuation and can provide liquidity where your, let's say, more general, popular, large custodians do not. And they're not. If you go to one of the large general custodians and broker dealers, you're not going to get the same the same quality of execution in the context of a wrap program, unless you are a dual registrant that specializes in that type of instrument, or your affiliate. If you trade through an affiliate ABD, they're likely not to get the same type of execution quality that one of these boutiques will get. Again, in these specialized areas in the market. So that's just one thing to take away. I think the Lockwood case is really an amazing case because it imposes so many costs on firms that are sponsoring, and I'll get to in a second, that are recommending wrap programs that you don't see in, it's not in the statute, it's not in the regulation. It's just, okay, you got to look at the Lockwood case now to see what your expectations are as a sponsor of wrap programs, and also as a retail firm that recommends wrap programs. So lots of costs imposed in the context of an enforcement case, but I think this is going to be one of those standards that the SEC looks to in the future, and it's unfortunate that it's coming to the fore in the context of an enforcement case. But a couple of bullets on slide 12 here that I just want to emphasize, which are really they're very interesting. The last sub-bullet point that Issa talked about, that the portfolio manager is going to send its conclusion of why it believes that it's getting best execution. It's going to send it to Lockwood. So now Lockwood has this. It has to do something with it. And by the way, I should mention that these were things that Lockwood agreed to in undertakings in the settlement. But now that Lockwood's going to be getting this information, it has to do something with it. And actually, there was another thing in the enforcement case, that Lockwood agreed to provide more detail regarding the consequences of a portfolio manager's failure to satisfy Lockwood that the manager is complying with his best execution obligations. So now Lockwood is playing the role of policeman, of supervising the portfolio manager's conclusion on best execution. And now, think about that. That is a real thing that Lockwood is taking on, is a real cost. That every time that it's going to look at the best execution quality of the portfolio manager and say, hey, you didn't do a good enough job here, and now you're fired from the platform. Another thing is the very last bullet on the page on slide 12, similar downstream impact on retail firms. So now Lockwood's not just providing this to for its own internal usage, but it's providing it to clients, and it's providing information to retail firms that are recommending the portfolio managers. Guess what? All those firms now are going to be expected to basically do something with that information. They're going to be expected to take that information in, evaluate it, and use it in the course of their recommendation of portfolio manager 1 versus portfolio manager 2 versus portfolio manager 3, etc. And I can see in the future a case brought by the SEC against one of the retail firms for not doing a good enough job of taking that information into account and documenting how it impacted their analysis of which portfolio manager to recommend. So there are lots of ripple effects here from this case, both for sponsors of wrap programs in the future. And for retail firms, and they're now going to be getting this information, they're going to have to use it and take into account and document their usage of it. So now we have a best execution practices of third-party portfolio managers impacting the suitability and recommendations analysis of retail advisors. So you can see best execution is now having all these impacts on third-party firms that are not actually the ones deciding on where to place send a trade. All these, again, ripple effects both on the sponsor and the retail advisors.
Great. Yeah, thanks. Thanks for that. Just a quick housekeeping note. For those of you who'd like to receive CLE credit for today's webcast, our confirmation code is enforcement. So again, if you're looking to receive CLE credit for today's webcast, the code is enforcement. So please use this code for the sign-in sheet available for download from your viewing console. And with that, we're going to pivot and turn to the standard of care. And obviously, the SEC rulemaking agenda continues to be dominated by the SEC's consideration of proposed best interest regulation for broker-dealers, the accompanying interpretive reliefs for advisors. So we're going to turn it over to Ben Marzouk to walk us through recent developments with respect to the standard of care.
Thanks, Cliff. So yeah, I wanted to use this section to give an update on the SEC's proposed standard of conduct rulemaking. We did cover this rulemaking at a high level during our last advisor webinar since it had only freshly been released, but I wanted to just spend a minute reminding everyone about the rulemaking and what it did for background purposes. So on April 18th, the SEC proposed a set of reforms that impacted the duties and standards of broker-dealers and investment advisors providing retail investment advice. The vote was 4-1, and it was a contentious 4-1 at the commissioner level, with two of the yes votes at the time, Commissioner Jackson and Pierce, voicing some serious concerns with the proposal. There's also a new commissioner at the SEC just confirmed this last week to replace Michael Piwar, and that may shake things up even further. So the rule was really broken into three components. First, regulation best interest, which established a best interest standard of conduct for broker-dealers. Second, Form CRS and titling requirement, which required broker-dealers and advisors to summarize their relationship to retail investors at the outset of the relationship, and then also restricted the use of the term advisor or advisor, both with an E and O, by broker-dealers. And then third, the SEC interpretation regarding the standard of conduct for investment advisors. Didn't really change anything about the IA standard, just restated it and requested comment on certain enhancements to the standard. So moving to the public comments, what we wanted to do for this update was summarize the public comments received on this rule proposal. As you probably know, the SEC comment period was only 90 days, and it closed August 7th, 2018, so all the comments have already been submitted and are in the process of now being digested by the SEC staff. There were several thousand comment letters submitted to the SEC, but we wanted to highlight a few of the key comments from the major financial services industry groups. And these industry groups can really be broken into three buckets based on their focus. First, we have the consumer groups, and here we're highlighting Consumer Federation of America, AARP, and Better Markets. Second, we have groups representing the broker-dealer industry, and mainly here led by SIFMA and FSI. And then third bucket would be groups representing the investment advisor industry, which the main leader there is the Investment Advisor Association that we'll focus on. So we'll turn to each one of these three buckets and briefly summarize the key comments from them. First, for the pro-consumer comment letters, the general theme espoused was that the rulemaking didn't go far enough, that Regulation BI was too weak, that it wasn't really a true fiduciary duty, and that now we have two completely separate standard of care, one for broker-dealers, a suitability plus or best interest standard, whatever that means, and then a separate one for advisors, a true fiduciary standard with duties of care and loyalty, and that these competing standards would lead to investor confusion. So these groups really felt that the SEC should have gone that extra step further and made Regulation BI a true fiduciary standard that would actually parallel the advisor standard. In addition, these consumer group letters felt the Form CRS disclosures weren't clear or straightforward for the average investor, and in fact afforded advisors a huge amount of discretion regarding the content in the disclosure. Many felt that the rules should go beyond the general disclosure requirement and actually have specific requirements or enforcement mechanisms built into the rules. And there is some specific language required to be in Form CRS, but these groups felt it should have gone farther with the requirements for the actual content. And then finally, these consumer groups addressed the cost-benefit analysis in the rules, which they felt underplayed the investor harm and confusion caused by these differing standards, and also that the SEC should expand private remedies for the violations of the rule, including prohibiting the waivers of class actions that brokers and advisors oftentimes put in their customer agreements. So moving then to the second bucket with the broker-dealer comments. So if the consumer groups claim that the SEC proposal didn't go far enough, it's not surprising that the broker-dealer groups argued that the proposal went too far. More specifically, the brokerage community generally supported the SEC efforts and was actually not opposed to enhancing the standard of care. However, they felt that Regulation BI wasn't clear in certain respects and needed more definitions surrounding material conflicts of interest. Remember, to meet the best interest standard, the SEC's proposal requires disclosure and mitigation or elimination of any material conflict of interest. So the brokerage groups felt that there wasn't enough details surrounding, one, what was meant by material conflicts of interest, two, how exactly firms should mitigate these conflicts, and then third, when mitigation isn't enough and when full elimination would actually be called for under the proposal. So regarding the disclosures, especially the dual and potentially overlapping disclosures called for by Reg BI and also Form CRS, these comment letters felt that it was complete disclosure overload, that investors wouldn't read them, and that the ones who did would be confused and might even not seek out the help of a financial services professional because of that confusion. Finally, the brokerage letters were focused on this idea, and this is key, of preserving investor access to diverse business models. They felt that the proposals were really tilted in favor of the advisory fee-based model, and that some investors would benefit from a one-time commission, a transaction-based model. So in that respect, they wanted to preserve the BD model, and that would be tough, they said, because the brokerage model is structured really around inherent conflicts, and the rulemaking stands for this notion that these conflicts must be sufficiently mitigated or completely eliminated. And, well, you know, that may pose some challenges for the long-term viability of the broker-dealer model if they have to continually mitigate or eliminate these inherent conflicts. And then finally, moving to the investment advisor perspective. So the investment advisor groups generally supported Regulation BI. They wanted to extend the fiduciary principles, I suppose not surprisingly, to all financial services professionals and even the playing field, so to speak. They were, however, worried about the potential gaps between the standard in BI and the investment advisor fiduciary duty, especially for the advisory activities performed by duly registered broker-dealer and advisor reps, particularly if the broker-dealer is relying on that exclusion from investment advisor registration for only providing advice that's solely incidental to the brokerage activities. So they wanted a little bit more clarity around that. For Form CRS, the advisor group was opposed to this proposal and felt it wouldn't be very effective and might do more harm than good, in fact. They also advocated for the SEC to allow advisors to use their Form ADV Part 2 disclosures to satisfy the requirements by perhaps even cross-referencing the Form ADV hyperlink when providing the Form CRS, so they wouldn't have to duplicate the text and the work there. And then finally, for the investment advisor standard of care interpretation, the advisor groups supported the principles of the interpretation, but they really didn't think it should be codified in a specific rule. They were essentially saying that the status quo is fine and that there's no need to really issue this interpretation. So I guess I wanted to kick this to Michael and Cliff to sort of talk about what's next for the proposal, but I guess in the interest of time, we might want to move on to I believe the Testimonial Rule proposal for enforcement action.
So just quickly, I mean, Chairman Clayton is very, very committed to getting this done, and when we say this done, it's Reg BI. CRS, we may see take a different path. It's received a lot of criticism. The SEC staff continues to meet with folks, so do the commissioners, but one thing they're being very quiet about is any timing, so we really don't have a great sense of the timing of any final rule. What we'd like to do is sort of pivot and really talk, for the remaining part of this on enforcement cases. And we're going to look first at the testimonial cases that came out, and from there we're going to go to the PaytoPlay, and then we're going to talk about the share class initiative, and then other enforcement. So first the testimonial, and I'm going to hand it over to Issa to tee that up.
Great. Thank you so much, Cliff, and thanks, Ben, for the excellent summary of the best interest proposals. I'm going to quickly run through some background here regarding the testimonial rule before I hand it off to Brian Rubin, our partner in our D.C. office, to talk about the actions that were recently taken. And you might be asking yourself, why are we talking so much about enforcement? Well, it seems like the SEC these days is doing a lot of regulation through enforcement. So this is going to be the topic of the rest of our webcast here, and I think helpful as firms try to develop policies and procedures, compliance processes, et cetera, to deal with and kind of interpret their obligations under these rules. So today, we're going to go through a recent spate of enforcement actions that were taken against certain firms relating to their violations of the testimonial rule, specifically arising out of a social media context. Just a little bit of background here. Rule 20641A1 under the Advisors Act, commonly termed or commonly known as the Testimonial Rule, prohibits an investment advisor from publishing, circulating, or distributing an advertisement that refers directly or indirectly to any testimonial concerning the advisor or concerning any advice, analysis, report, or other service rendered by the advisor. Basically what the SEC says in that rule is it's a misleading thing to publish an advertisement that touts your abilities as an investment advisor because clients are not receiving the full panoply or the full range of experiences of all your clients. You could be cherry picking one particular client's experience with you. Another important thing to note before I hand it off to Brian here is that the term testimonial isn't really defined in Rule 20641, but the SEC has consistently interpreted that term to include any statement of a client's experience with or endorsement of an investment advisor. And I should also mention that the SEC has taken an occasion to clarify how the term testimonial is to be interpreted in the context of social media. And I'm going to provide a little more background about that interpretation in an upcoming slide. But basically, the SEC has issued some guidance through a guidance update in 2014 that spoke about how the term testimonial is to be interpreted in the context of social media and websites such as Yelp or Google Business or any of those others that provide a way for clients to provide reviews about an advisor. So with that, I'm just going to hand it off to Brian, having gone through that background.
Thanks, Issa. So the cases are pretty straightforward. IAs or IARs posted testimonials or had testimonials posted for them, and they were charged, and there was also a marketing consultant charged for causing the violations. There are a few interesting facts and legal issues that I want to highlight here. First, these cases cover inadvertent violations, more or less, and then vertent, if that's the right word, or more intentional violations. In terms of the inadvertent, one of the firms, the duly registered firm, was celebrating its 50th anniversary, so it did what a lot of us would do and do is create a video to use at its party. and the video contains statements from 27 advisory clients regarding their experiences with the firm, and that's probably fine. The firm then posted the video on its public website and then on YouTube, where it had 291 views over 5 years, so it wasn't very popular. They then created a shorter version, an 8-minute version of the video, and again posted it on its website and posted it on YouTube. So that is what I'm sort of calling the inadvertent, where they might have stepped into this issue without really noticing that they were doing so, because they were sort of just publicizing what they were doing. The other firms acted more intentionally by hiring an outside marketing firm to publicize them. There was this company called Create Your Fate, and the fate, as it turned out, was SEC enforcement actions. What Create Your Fate did was it contacted advisory firms and said that they would in turn reach out to advisory clients and solicit testimonials for publication on websites, Google, Yelp, Facebook, that sort of thing. The firm claimed to be 100% compliant for investment advisors, but it wasn't, and apparently most of the firms didn't check the basic requirements that Issa mentioned and that he'll talk about in a couple of minutes. All of the testimonials related to the RIA or the representatives of the firm, as well as advice and services they rendered. And among the words of praise that were used, they were described as being trustworthy, knowledgeable, high level of service, generating significant investment returns. So the kind of things that you would expect with these kinds of testimonials or touting issues. The second interesting issue related to these cases is the possible genesis of the cases. 4 of the cases are related. 3 of them involved RIAs or IARs hiring Create Your Fate, and one of the cases was against the owner of Create Your Fate. So the SEC may have found one advisor, and then based on that relationship with Create Your Fate led to the other enforcement actions. The third interesting issue is that one RIA was cited in the settlement with Create Your Fate, but it wasn't ultimately charged in an enforcement action. So Schwartz of Create Your Fate reached out to what's called Advisor A in the order and solicited testimonials, posted them on Facebook and Twitter and YouTube. Advisor A realized there was a problem, sent Schwartz information on the testimonial rule, and asked that the testimonials be deleted. They weren't taken down for 6 months, and Schwartz continued this practice with other investment advisors. Advisor A was not charged. So if you see something stupid being done or something questionable being done, that course of action is to stop doing it, and you may get lucky like Advisor A got lucky. The fourth interesting issue was even neutral websites can be problematic if they're not handled properly. One of the firms had separate issues related to Yelp. Yelp in and of itself might be fine. In this case, the firm orally solicited statements from clients and from other individuals, which presumably means they weren't clients, and had the clients and non-clients make statements of the type that we talked about before: purchasing unique investments, protecting clients from risk, helping clients generate significant investments, that sort of thing. And that firm was charged for those violations. The last point I want to emphasize with regard to these cases is one of the firms got credit for remedial acts. The settlement dealing with Romano Brothers, the SEC noted that it considered remedial acts promptly taken by the firm, including hiring a new chief compliance officer and updating its compliance manual and training program. So keep in mind that if you do something wrong, you should correct your conduct as best you can, and you may get credit for it even if there is a subsequent enforcement action. And Issa, I will kick it back to you.
Thanks, Brian. That was great. Just a final quick note. I know we're running short on time here. Just some very brief takeaways. I mentioned earlier that there was a 2014 guidance update that was issued that kind of explained the application of the testimonial rule in the context of social media. what we have here in these cases that Brian just discussed is an application of that guidance in the enforcement context. And what the real message from that 2014 guidance update was that, hey, it's not a problem in the SEC's eyes for Yelp reviews of investment advisors to be out there. They like it when consumers have more information about the advisors that they deal with. Where we have a problem is when an advisor gets entangled with the reviews, starts trying to direct the reviews in a certain direction, or starts trying to influence the presentation or the content of the reviews in some way. And that's what Brian really highlighted in those cases, was investment advisors trying to get certain clients to say certain things about them and then orchestrating the posting of those reviews on their Yelp page, on their Google page, what have you. So, just some compliance kind of takeaways here. You should make very clear, crystal clear in your policies and procedures relating to social media use that your personnel are absolutely prohibited from soliciting or influencing testimonials or other commentary about the advisor or the services of the personnel themselves on social media pages. They just a flat out no. And second, another takeaway here is that given that much of the activity that took place here happened over email, so much of the violative activity was coordinated over email with, Create Your Fate, with the clients themselves. You should really take a look at the search terms, your lexicon searches that you're doing with respect to email correspondence review to make sure that it includes search terms that kind of cover solicitation of testimonials. And with that, I will kick it to Sue to discuss the PaytoPlay, the recent PaytoPlay enforcement actions.
Thank you, Issa. The PaytoPlay Rule Investment Advisors Act Rule 2064-5 generally contains 3 prohibitions. First, there's a 2-year prohibition on the advisor providing compensated services to a government entity after a political contribution is made to a certain official of that entity. The PaytoPlay Rule also prohibits using third-party solicitors who are not themselves regulated persons subject to PaytoPlay restrictions on political contributions. And finally, the rule prohibits bundling and other efforts by advisors to solicit political contributions to certain officials of a government entity that the advisor is seeking to provide compensated services. Rule 2064-5 applies to advisors that are registered with the SEC and also foreign private advisors and exempt reporting advisors. Now, Brian will discuss recent pay-to-play enforcement cases.
Thank you, Sue. So these cases are very straightforward and not as interesting as the other ones. So there are campaign contributions followed by advisory services and fees related to public entities and pension plans. So just a few quick observations. First, it's really not clear how big a priority this is. On the one hand, it appears to be a priority. These settlements were the second wave of SEC settlements. In January of 2017, the SEC settled 10 other cases with investment advisors, 5 of which were reporting advisors. And the penalties here are actually a little bit larger. The 2017 cases, none of them was greater than $100,000, but this time around, the penalties in the 3 cases range from $100,000 to $500,000. On the other hand, these might not be a big priority. It's not formally a priority. So last year, the SEC included pay-to-play on its annual list of exam priorities for 2017, but this year's priorities, it disappeared. And that disappearance may relate to Chairman Clayton's view that the SEC is really more focused on issues like protecting retail investors, and this issue is somewhat removed from that. The second thing worth noting is it doesn't matter if there's an attempt to buy influence or it was a simple mistake or just basically ignoring the rules. There's no scienter or bad intent requirement here. And then the last point I want to emphasize is that even small contributions can trigger a penalty, and in one of the orders, a contribution of $500 was sufficient and was alleged by the SEC. So it's worth keeping an eye on this issue. And back to you.
Thank you, Brian. I'll just briefly mention a few takeaways on these cases that Brian just covered. First, compliance policies and procedures. Advisors, including exempt reporting advisors, should review their policies and procedures to ensure that those include monitoring and testing to detect and prevent violation of the pay-to-play rule. Exempt reporting advisors should also be aware of their compliance obligation of the pay-to-play rule. Second, a pre-clearance system. In addition to policies and procedures, advisors should also consider implementing a political contribution pre-clearance system. A system should require covered persons to pre-clear certain contributions. Covered persons should also be aware of the policies and mechanisms such as notifications, training, and certification of compliance. Finally, advisors should also ensure that their relevant employees and senior executives are adequately covered by their policies and procedures. Now, Brian Rubin will provide updates on share class self-reporting initiatives.
Thanks, Sue. So just a little shout-out. Gary Klein noted that verdant is, in fact, a word, and it means green with grass or other rich vegetation, so I didn't use the right word there. Okay, so share class disclosure issues. During the past few years, Cliff, Michael, I, and others have been very busy working on 12b1 issues related to full-blown investigations, settlements, exams, and more recently, the self-reporting initiative. As everybody on the call knows, during the past few years, the SEC has brought several cases against IAs relating to this issue, and the firms have been ordered to disgorge 12b1 fees to pay them back to clients in order to pay a penalty. And in February, the SEC announced the Share Class Selection Disclosure Initiative, which was really a carrot and stick approach. If firms self-reported, they would be subject to an SEC order charging non-scienter fraud and an order to disgorge, but there wouldn't be a penalty. And as Cliff alluded to earlier, they said there wouldn't be a best execution charge. On the other hand, if they don't self-report, but they should have, the SEC said that the penalties would be larger than in prior settlements, and there would likely be a best execution charge, and individuals could also be charged. Firms were supposed to self-report by June 12th, although many firms got extensions, and at least some of our clients got extensions until last week. During the past month, the staff has been reaching out to firms that self-reported, focusing on a few areas, and I'll highlight some of them. First, one of the basic issues that the staff has been reaching out to firms about is just to get a basic understanding of the firm's business and the firm's explanations if they do have defenses or mitigation dealing with certain of their disclosures or certain of their programs. So the staff is trying to get an understanding of the firm's perspective on the issue. Second, the staff has been asking about the number of clients affected. So when most firms provided data to the staff, they had the data based on the number of accounts, and for whatever reason, the SEC is focused on the number of clients as well. The third issue that the staff has raised is they are discussing the ratio of accounts that have been affected and that didn't get the lowest cost share class. And in general, the staff has said that firms that are reporting less than 90%, the staff is questioning because most of the firms reported 90% or more. So that's something to look at if you haven't looked at that issue yet. The fourth issue is the staff has looked at how firms are calculating prejudgment interest. And if anybody has questions about that, there are online calculators, and we'd be happy to provide links to that. The fifth issue is a de minimis issue. A number of firms, when doing their analysis, were proposing either specifically proposing to the staff or they didn't include de minimis amounts. So if they were paying, it looked like they would be required to pay back clients $10 or $25 or even $100. Some firms did not include that, and the staff has been asking questions, and as we understand it, the staff is likely to come up with a specific dollar amount that they will go back to the firms on, and they'll say to the firms, you don't have to pay back clients if the amount is less than X, but that amount will still have to be paid back to Treasury. And then the final issue is the staff has been asking a lot of firms to sign tolling agreements, giving the SEC 3 additional months to bring a case until December. So what do we anticipate will happen next is we think there will probably be at least 2 tranches. So one group of case will be brought before the end of the year, and then there will be at least one group of cases brought after that. The other things that firms should keep in mind is that even after the SEC order comes out, there will still be some work to be done. Firms will have to take undertakings to the SEC regarding paying back the clients, regarding enhanced disclosures, and regarding policies and procedures. The second issue is that duly registered firms will likely be subject to statutory disqualification, and they'll have to deal with the FINRA on that. And then finally, public companies might need to seek waivers from the SEC so that those companies are not deemed ineligible issuers. So those are all issues that firms are going to have to look at.
Great. Thanks, Brian. We're going to turn now to wrap up. We have a couple of minutes left. We just want to mention 3 other enforcement cases of note. I'm going to turn it over to Issa to give some context here.
Sure. I'm just going to introduce these and then kick it over to Michael for a little more commentary. So the first case we have listed here is the Merrill Lynch case recently came out. That had to do with a failure to disclose a particular conflict of interest. Apparently Merrill Lynch had a financial incentive to keep a third-party manager on its platform, and it was otherwise going to terminate that manager, but kept them on and didn't really disclose what was going on there and all the deliberations that were happening to clients who were recommended that third-party manager. And then the last 2 cases, the MFS case and the Transamerica case, those 2 cases really highlight the SEC's keen interest now in algorithmic trading models, specifically their interest in ensuring that they're properly developed, maintained, that there's sufficient diligence of the models to make sure they're working as advertised, et cetera. And one notable aspect of the MFS case was that the SEC also identified a performance reporting issue with respect to the performance of the model. The SEC basically said that that MFS had they had advertised some performance of the model as hypothetical, but the model really wasn't even in existence during the years that they advertised. So that was a significant issue in the MFS case. And I was just going to kick it over to Michael for the final thoughts.
Sure. So given the fact I have 1 minute, I'll just mention a couple things on the Merrill case, because I think there are a lot of potential applications of the principles in that case. Issa gave the overview. What was going on is that Merrill had other relationships, other parts. Merrill is obviously a very big organization. It has the MLIM, the asset management arm, but also obviously has a global banking and markets arm that does underwriting, investment banking, M&A, corporate, etc. And so that other arm had a relationship with another part of the third-party manager that was going to otherwise be terminated. And the manager's arm got wind of the impending termination and appealed to the investment management arm within Merrill, saying, "Hey, we have a broader relationship here." Merrill was really pegged to provide to be the book runner in an upcoming offering of the U.S. subsidiary of the third-party manager. So this outside kind of business relationship had an impact, and impact. Merrill did not take them off the platform. They eventually went through the process and got approved, and but the SEC said, hey, you have marketing material that touts your process. You have the ADB that touts your due diligence process. Nowhere did you tell people that part of the factors you're going to take into consideration, whether someone stays on your platform or other business relationships, that your affiliate's going to, get all this money from potential investment banking business. And so I wouldn't get caught up on the particulars fact pattern, but just the general principle that if you have outside business interests or relationships that are impacting your due diligence process, your decision of who to hire, fire, retain, that is all fertile ground for enforcement in the future. And I think it's a really good example of, if and when the SEC adopts its, proposed fiduciary proposal for investment advisors. This is a great example of some of the principles in that proposal. And because there are so many potential business relationships and things going on in the background, I think the case has a wide application to many, many advisors, even though the particular facts are going to vary. So I think keeping wider business relationships kind of segregated and making sure they don't kind of, impact the due diligence and the investment management decisions is going to be an important thing going forward, or else you're going to have a very high burden of disclosure, which you may not be willing to live with and tolerate if you really have full disclosure of, hey, we take into consideration, these business interests in deciding who we're going to retain and fire. So I think that case is an important case.
Yeah, thanks. And with that, we'll wrap up. Thanks, everyone, for joining us today. And we hope that you'll join us for the fourth quarter update. It's just, the year's just flying by. It's amazing. But, yeah, the fourth quarter update, and we'll be announcing a date soon for that. As a reminder, if you want to receive CLE credit for this webcast, please download the CLE sign-in sheet and evaluation form from your viewing console and follow the instructions for submission. And, again, if you have any questions or if you'd like a copy of the slide deck, just contact any one of us, and we're happy to follow up with you. So, again, thanks again, everyone.